And you first.
Your Honors, may it please the Court. My name is Casey Harrison. I represent the former husband, Ryan Tritschler. I'd like to reserve 5 minutes for rebuttal, please.
You got it.
This is an appeal of a final judgment of dissolution of marriage, including errors impacting alimony, child support, and equitable distribution. The former wife has already conceded possible errors as to alimony and child support.
I couldn't hear you.
The former wife has already...
Remember, you're dealing with an old person.
I'm sorry, Your Honor. Has already conceded possible errors as to alimony and child support.
Let me ask you a silly question. This is such a long judgment, and it's so detailed and complicated. Do we know who prepared that?
Yes, Your Honor. The counsel were instructed to submit written closing arguments and propose final judgment.
Both sides?
Both sides,
and
Your
the judge picked one or the other, or crafted his own?
It appears to us that the judge picked the former wife's counsel's proposed judgment.
You're not raising a Perlow issue that adopted one side without thought. That's not an issue in
Well,
this case.
that is what appears to be the case. Unfortunately, those are not in the record.
I saw.
That's correct.
Okay. All right. Let's proceed. Thank you.
The former wife has conceded possible errors as to alimony and child support. Specifically, she conceded...
She doesn't believe the remedy is reversal.
Whether it's reversal or correction, specifically she conceded that the court erred in failing to
You believe that the whole thing should be reversed?
Yes, Your Honor.
Okay, let's just go with why you think that.
Okay, I'd like to begin by addressing equitable distribution then. The date of filing in this case was July 17th, 2012. The date of trial was December 6th and 7th, 2017. Many of the issues here stem from the equitable distribution report created by the wife's expert, CPA Robert Cheatham. Mr. Cheatham's report was adopted by the lower court in its final judgment, and it divides marital and some non-marital assets to arrive at an equalizing payment from the husband to the wife of $128,000 and change.
Were you dealing with 3 paragraphs in the judgment? Paragraph 23, which purportedly identifies the marital assets and liabilities, and then paragraph 24 and 25, which purports to distribute those assets and liabilities.
That's correct, Your Honor. But
there's some assets that are distributed that aren't identified, and some assets that are identified that aren't distributed. Am I reading that correctly?
That's correct. Jumping ahead a bit to address that, one of the large issues is that the court adopts Mr. Cheatham's report, directs that the parties distribute the assets equally according to that report, pursuant to his equalizing payment. It then has its own separate list of assets in the body of the final judgment, as well as awards for those assets, which does not agree with Cheatham's report in terms of the items, valuations, or distributions. The result on its...
The court didn't accept all of his testimony, is that correct?
Your Honor, it appears that...
Apparently rejected some because the judgment refers to different values of the marital home and the liabilities. Those numbers don't match up to the expert's report.
There is language in the final judgment that there was some sort of stipulation to have a different value for the marital residence that is not reflected in Cheatham's report. That is...
And he does not. Does he identify what valuation date he uses, date of filing, or some other date?
Yes, Your Honor. And unfortunately, page 2 of Cheatham's report is actually missing from the final judgment. This is the page that actually has the calculations and equalizing payment. So
the confusion here, at least helps.
That is part of the confusion. Now, that was an exhibit later in the record. It's not actually in the final judgment, but on that page 2, there are valuation dates.
Well, but that's of record in the report, but not attached to the judgment? Is that what you're saying?
That's correct.
So we don't know for a fact it would be identical unless there's a stipulation to that effect.
Well, it's an exhibit that was introduced at trial, but the final judgment does not adopt the exhibit in full. Okay. But looking at the full exhibit, there are valuation dates set forth for most of the assets of January 30th, 2017. It's a date over 5 years after the date of filing, almost as of the final hearing. One of the issues this raises is, for example, the double counting of $90,000 against the former husband. Now, the first two assets listed on Mr. Cheatham's report are withdrawals by each party from a joint Bank of America account. That's $90,000 in the case of the husband and $62,000 in the case of the wife. Now, Mr. Cheatham's own testimony and evidence showed that the husband's $90,000 withdrawal actually came from the Bank of America account to a Charles Schwab account, two separate transfers, September 2013 and January 2015. He then values the Schwab account as of September 30th, 2017, treats it as a marital asset in its entirety, and divides it evenly between the parties. In essence, what he's done is debited $90,000 against the husband twice by considering the increased Schwab account value and the transfers giving rise to that increase. Now, there's a First District case, Marcel v. Marcel, that addresses this kind of situation directly. I believe it's clearly a mathematical error, but it's also an abuse of the carefully reasoned discretion required in selecting valuation dates. And in Marcel, there was a situation where these valuation dates were sort of haphazardly selected, and the result was that they double counted funds that had been transferred from one account and later to another account. By valuing the repository account as of a later date, they double counted those funds. Here, in this case, that's a $45,000 swing against the former husband. Now, several other assets, as I mentioned, were valued almost as of the date of the final hearing, and for a court to make that kind of departure requires a finding that it's just inequitable under the circumstances. We don't have that here, and the record shows that the result was actually clearly inequitable. Cheatham attributed the majority of accounts to the husband in full with an almost date of trial value, and this raised the husband's equalizing payment further because some of these accounts increased in value during the pendency of the...
So the court adopted the expert's equalizing payment?
That's correct, yes, Your Honor. The court explicitly adopted the equalizing payment.
That was based on different figures than what the parties had contended in some instances?
In some instances, yes, it was.
We don't know how he got those numbers.
Some he even testified, I don't know where these numbers came from. They were just given to me. So they're different from what showed on the
Well,
parties.
I mean, just the party's joint checking account, he valued at $35,000. I mean, the party's joint checking account was valued at $35,000, but the expert said it was $152,000, something
in
crazy
essence,
like
yes,
that.
the court valued the joint checking account in the body of the final judgment at $35,000.
I mean, the final judgment.
Mr. Cheatham valued it at, as you said, essentially $152,000 because of those two withdrawals he counted against each party.
Well, that affected the equalizing payment that the judge used. The numbers didn't add up. I mean, it just seems to me this whole case is riddled with confusion and math that doesn't work. I mean, both sides of the equation are supposed to come out equal. And it just seems to me there's such a distinction. I don't know that this case has to go back for a remand, but I'm leaning that that's the only solution I can think of that makes sense. I want to hear what your opponent has to say.
Yeah, yes, Your Honor, essentially that's what we would be requesting, because even setting aside the alimony and child support for a moment, the equitable distribution here is so riddled with problems, disagreement, conflicts, and omissions.
Well, I mean, the other thing is the alimony seems like it was based upon gross.
Yes, Your Honor.
Can you help me out there?
Yes, Your Honor. The court did explicitly consider gross income when it made alimony findings. It didn't even make all of the required alimony findings, but it looked at gross income, and it awarded substantial alimony, $2,000 a month, even though the former wife has a substantial income. It exceeded her stated need of at least $1,800 a month without making any specific findings in support of that.
And there's some other things I think we could get around. The failure to identify the termination date of alimony might might not be insurmountable, but that's another error that appears on the face of the judgment.
Yes, Your Honor, as well as step-down calculations for child support.
Well, that's probably moot at this point, correct?
We would
There's no
be
minors
getting-
left.
There is, yes, Your Honor, there is one.
There is one
Actually,
still?
I'm sorry, there may be two. One is close to reaching majority. If
I think one is 18, the other is 16.
Yes, that's correct,
Okay,
Your Honor.
So it is a violation.
The step-down calculation is important, and in fact, the gross-up method should be used in that because,
Did your client's employment that resulted in his FRS pension predate the date of marriage?
yes, Your Honor, he was, one thing about that, the court states FRS, it actually is a federal employment retirement system, not Florida retirement. It's a military pension. He was in the military for 10 years prior to the marriage.
And
But
there's no distinction between marital and non-marital interest in that pension?
correct, Your Honor, it was simply split in half without any kind of findings made as to marital and non-marital.
And there's no justification for the trial court using different dates of valuation in your case other than the date of filing? The court would have discretion to use different dates, but there has to be justification somewhere in the record. Is there any justification in the record?
There's, in short, no, I don't believe so, Your Honor. We can see that the court can use its discretion in arriving at those valuation dates, but what we have here is...
Your opponent says the dates were carefully explained, but I'm at a loss finding where in the record they were carefully explained.
Yes, Your Honor, I don't agree that they were carefully explained. In my estimation, Mr. Cheatham essentially just had a 2017 statement and chose that's little more than that.
All right, I don't want to, is there anything you want to add? Now's your time because you're coming down to your 5 minutes.
Just a couple of other notes about the equitable distribution. I think we've touched on most of it, but some of the two other significant examples. The final judgment awarded half the equity in the thrift savings plan. It valued at over $190,000. It split the equity in that account between the parties. Cheatham's report addressed the item at a different value and distributed in full only to the husband. The result was another huge bump in his equalizing payment for assets or parts of assets that the court awarded to the wife.
Did Cheatham distribute that to the husband because that was, the increase was based on his own individual efforts, or not?
No, Your Honor, there were no findings made as to that. Now Cheatham did at least separate what he found to be a non-marital portion of that,
Okay.
as well as tax deduction, which the court did not take into account, but he simply put it in the husband's column, tacked onto his equalizing payment, whereas the court said this is split in half. The same could be said with the wife's personal bank account, which the final judgment awarded half the value of that to the wife, but Mr. Cheatham's report was completely silent as to that account. Doesn't mention it at all. This would have been a significant offset to the husband's equalizing payment as well, because that was a $79,000 account as of June 2015. These aren't things that can be simply corrected by relying on Cheatham's report or cherry-picking values and awards. These are significant facial mathematical errors, sufficiency of the evidence, that are prejudicial to the husband to the tune of tens of thousands of dollars.
This is not a situation where you can just remand for correction based on Cheatham's report, given the fact that time has expired and things may have increased or decreased, and there may be new evidence.
Correct, Your Honor. Unfortunately, this is something that I believe would need to be essentially readdressed by evidentiary hearing. Thank you.
I'll save you the 5 minutes. Ms. Henney, your turn.
May it please the court, my name is Jean Henney and I represent the wife in this case. Part of the problem in this case is that there's no statement of the facts by the appellant. So there was no summary of what the testimony actually was. I have written down, and I didn't copy it, but I have on the transcript page 40 to 41 with the husband's testimony. It says his pension was accumulated in 2002 and it was not a military pension. I would need to look at the record there, but counsel just represented that was not the case. But the problem with this case is that the husband presented no testimony. No exhibits, no expert testimony, and no valuations as to what he wanted the court to value.
Does he need to do that if he's attacking internal inconsistencies on the face of the judgment and noncompliance with state statute that the court was obligated to comply with?
Okay, well, all right, let's break that down. Okay, so we have an equitable distribution. The court ordered equitable distribution in accordance with Mr. Cheatham's findings. The court did make, I can't argue that the court didn't make other inconsistent findings in the body of the final judgment, which from the appellate record, I couldn't see where this final judgment came from. Maybe he read it somewhere in the appellate record I didn't see. But
You're saying the judge did his own judgment?
actually, the appellate record, I couldn't find where it indicates.
You weren't the trial lawyer.
Right.
Okay, so I won't ask you something that's beyond your cable toe.
Yeah, yeah. So what we have is the wife hired Bob Cheatham, experienced forensic accountant. They gave him tax returns for several years, bank reports, credit card statements, financial affidavits, all of them that the parties filed. They gave him all of the brokerage accounts. They gave him all these statements. He charted them, he analyzed them, he checked for commingling. He was given an assignment, and his assignment was to separate marital from non-marital assets and to value them and to do a valuation date. The husband took his deposition, and then Mr. Cheatham testified at trial. So he explained why he valued some things at certain dates. And in terms of the thrift account, I did copy that. It's the testimony's at page 116, and he said he separated that as non-marital assets because he said that this plan is not buying and selling assets. It's very easy to determine what was post-filing and non-marital to what the value was at the date of filing and the passive growth on both. So that account was the one account that he said, I can figure out what's non-marital here. And when you look at the other account, the main one that the husband's complaining about is the 8829. He claims that all of that is non-marital. Well, Mr. Cheatham explained why he valued that and the way in which he valued it, and that's testimony at page 113. And he says there's activity taking place within this account post-filing, and what basically transpired were that assets were, these were the assets on hand at the filing date, and he could identify those values, but then when he looked post-filing, he still had money that was being moved in and out of that account, and so he valued that account at a later valuation date without carving out non-marital assets. Now, the husband says that's non-marital. If you look at the husband's closing argument, and that's the first place, if you look at every affidavit that the husband filed, which includes the day before the final hearing, he does not ask for any non-marital assets to be cut out other than an airplane and a car and something else. These accounts that he's now saying, these $350,000 worth of accounts that he's saying are non-marital, weren't claimed non-marital beforehand. And so his equitable distribution chart, it doesn't have how he even comes up with those dates. And on the thrift saving account.
But there was no stipulation as to evaluation dates or whether they should be described as marital or non-marital. You're saying they didn't claim it non-marital, but there was no stipulation.
Right.
One way or the other.
The only thing, so I'm always telling my clients, the court is asking, did the trial judge make any errors with the information it had in front of it at the time it made its decision? Well, the only information that the trial judge had in front of it at the time it's made its decision was the expert testimony of Mr. Cheatham. The husband says, well, now, and so what the husband wants a retrial for is so the husband can properly try this case. And what happened was the husband did not properly try this case because he didn't properly contest Mr. Cheatham's valuations. There's no counter valuations that were offered.
You concede error on some of the issues.
I have to concede error on some of the issues.
Okay, so tell me, what's your remedy to correct the errors you concede, but yet not correct the errors he complains of?
Okay, this is what my, okay, it has to go back for a remand to determine whether any other form of alimony was reasonable and appropriate. It has to go back for...
Also for, how it terminates.
It has to go back for how alimony terminates upon death and remarriage. It has to go back on a calculation of child support.
What about the gross valuation to determine need and ability as opposed to net income?
Well, I do not believe that the trial court awarded alimony based on the gross income. He said...
it talks about the gross income in the judgment.
In the relative financial picture of the parties.
And curiously enough, the difference between the two incomes is about $4,000, and the alimony, curiously enough, comes out to be $2,000 when the wife asks for $1,800.
Well, the wife shows in her financial affidavit a net need of $2,500 for alimony. And then in the husband's financial income, the first two he filed, it showed a net surplus of $3,500. The husband's not arguing he cannot afford to pay the $2,000 in alimony. He's just saying that the wife doesn't need it.
Well, that's part of needing the bill. That's a proper argument.
That's a proper argument, but her financial affidavit does show that she needed it. She, in closing argument, she asked for $2,000.
The mistake I'm referring to is the judge can't use the gross in determining need and ability.
Right. He can't, but I don't think he looked at the relative financial picture saying this is a gross amount, but I think he can, it's properly appropriate to look at the net incomes that were shown, and both of the parties testified to their financial affidavits, and they are in evidence to say, look, this is the net, and this shows still a need. But if the court's sending it back and it feels like the court needs to clarify that 2,000 amount was based on a net figure rather than a gross figure, I think that would be appropriate. And then I think this court can ask the trial court, the same trial court that heard this case and all of the testimony and Mr. Cheatham's testimony, to conform the factual findings.
Well, just as one example that comes to mind that might need to be updated, didn't the wife testify she may or may not have a job because she might not be qualified if she's moved from job A and offered a different position? It might not be something she could take. Now, without telling me, we don't know what's happened during the intervening period between the final judgment being entered or the case argued and this appeal. That would answer that question.
Well, I think that could be resolved with a modification. That would be much better than to completely retry this case.
But then the burden is totally different. That seems to me, us being more than a referee, we would be a decider of who do we put the burden on, as opposed to letting the trial judge take first dibs that they normally do on how to weigh the evidence.
Right. Well, the trial judge weighed the evidence, and he looked at her precarious health, her precarious...
Was that in the record? I know it's unfortunate when someone comes down with cancer. It found in the final judgment, but I didn't see any of that in the transcript.
The wife testified, yes, to her surgery. There were 2 volumes of the transcript, so the wife's testimony is one volume, and but it should appear all as the one testimony.
But the wife saying it's in there somewhere.
Yes, but it shows again what happens when the appellant does a one-page statement of the facts. But those factual findings are in the trial court concerning her 11 surgeries and chemo, radiation.
What causes me a little concern is there are assets, marital assets, awarded to either party that aren't identified in the final judgment. They're not valued. Loans thereon aren't identified. Jewelry's not identified or valued. Mr. Cheatham took in account the tax impact for the savings plan and attributed a value, but the trial court didn't transfer that to the final judgment. There's vehicles that aren't identified or valued. The court never really identified what was non-marital. So this is a little bit more than just going back and saying, Circuit Judge, please take a closer look at Mr. Cheatham's report and, amend your final judgment to correspond there too, don't you think?
No, well, what I don't, because the judge adopted Mr. Cheatham's report, so he
Well, that means he
the findings.
adopted it as true, so it should have been reflected in the final judgment, and it's not.
Right. Well, it is part of the final judgment, and is adopted. I would encourage this court to read all of Mr. Cheatham's testimony before they send it back to completely reopen it, because Mr. Cheatham does explain, I valued the car at this for this reason. Now, he did the $15,000. He says, I don't know where I came up with the $15,000 figure for the wife's Explorer. The husband valued it at $13,000, the wife, I think, said $10,000 in the financial affidavit. So there's one thing, that he can't say where he came up with the values. But the other things he does value. And what happened is, what makes this so confusing is the parties had this account called 9105, and that was their joint account. They put their marital earnings there. Then it was taken out here, and it was put here, and it was put here, and it was put here. Mr. Cheatham tracked all of that down. And so he explained why he valued things, what was the basis of his valuations, and then he put all of the documentation for his valuations into the record, including exhibits and charts. So the husband doesn't come up with any alternative thing. So I think the trial court can conform its factual findings in accordance, or give the trial court the opportunity to do that based on what the trial court already considered.
Would there be any consideration as to whether these particular accounts that were valued at that date and time of the final hearing, whether they have increased or decreased in value? Can the court consider that or not, or just take Mr. Cheatham's report as a fixed time with which he has to comply?
I think the wife would request that the parties had a final hearing, they gave it their best shot. They spent a lot of money on Mr. Cheatham's report and testimony. It's very well documented, and it's very well explained. I think at some point the marriage needs to end. The parties' financial, it's an arbitrary snapshot we take anyway. This was difficult. The parties, petition, later separation, final hearing. He explained why. The husband says that you should have used an earlier date for evaluation. You don't get the passive income on this, but in his closing arguments, he concedes, okay, you value it here, but you still get the passive income on that. Mr. Cheatham tried to figure that out the best that he could. I would say the wife requests, take a snapshot, date a final hearing, look, Mr. Cheatham's report, he's been around a long time, and then give the trial court the opportunity to comply or to coordinate his factual findings with that report, if that was actually what the trial court was relying on, and not open this up to allow the husband to do now what he didn't do the first time. Are there any other questions?
You're just about out of time. No, you know how to end this thing.
Yeah.
All right.
Are there any other
Thanks
questions?
very much.
All right.
Ms. Harrison, you've got 5 minutes left.
Okay, just wanted to raise a few other things regarding
Why don't you
the...
address the argument that we shouldn't give you a second bite at the apple to do, not you, but to have trial counsel do something better that they didn't do as well as they should have the first time?
Well, Your Honor, I would disagree a little bit with the idea that these things weren't all before the court properly at that time. I mean, as to valuation dates, as an example, we're talking about two different things here. The decision of whether an item is marital or non-marital, and that is a fixed date. That's date of filing, in this case, 2012. And then the separate question of when that item...
It's fixed by statute, isn't it?
Yes, Your Honor, it is.
Unless there's a reason to vary from it, then that's on the trial judge to explain.
That is the earliest date of filing or date of separation. In this case, it's that 2012 date. The court didn't actually set aside any non-marital property except for Cheatham did set aside that portion of the thrift savings plan. I believe that was it. There are items that the parties actually agreed on their financial affidavits were husband's non-marital property. These are items that are in the husband's column as marital property in Cheatham's report.
Well, the jewelry is not identified or valued at all, correct? Just as an example.
Yeah, that is, there are a number of items that are
When you
not.
looked at Cheatham's report to say what kind of jewelry it was and how much it's worth?
There are a number of items that the court didn't value or identify, but then split between the parties. Some of those also don't appear on Cheatham's report, one of those being the wife's personal Bank of America account, which, as to that, and going back to the valuation dates a little bit, what happened here also is that by choosing those valuation dates, the court is, so say for the sake of argument something is marital, well, the court is now incorporating into that all of the husband's post-filing income and contributions into that account, but failed to do the same thing with respect to the wife's post-filing income or contributions, which also would have been substantial. That's another example of the inequity on the face of this.
You got 2 minutes.
Thank you, Your Honor. So those two separate questions, the treatment of the property and the valuation date, I think there are mistakes, significant mistakes as to both of those. And then the disposition of the assets. You know, we have a situation here where, looking at the final judgment, the party may think, I have to give up half of this thrift savings plan, but in this report that arrives at the equalizing payment, the court also directed I am to keep it all. Where do we end up with that? Simply put, even on top of all the errors that I believe are clear here, the final judgment is difficult to even interpret or carry out. Furnishings and fixtures, this is a small item admittedly, but Cheatham puts it all in the husband's column. The court, in the ordered and adjudged section, actually gives a time period during which the parties are to inventory and split the items. Same type of situation. And these are not novel issues. These were things that were argued before the court at trial. But unfortunately, the findings in the final judgment are based on insufficient evidence and full of mathematical errors and conflicts that are, I believe, clearly harmful to the husband. Thank you, Your Honor.
All right. Well done, well argued. Thank you for coming, both of you.
Thank you.
Are you good for one more?
Yes.